Yes.
Nevertheless, Lordship, I beg to item number 12, my lord. In this case, my lord, Mr. Subrata Bhuya, his argued this matter was due to his leg fracture, my lord, on last Saturday, my lord. He could not come to the court, my lord. After 4 weeks, my lord.
We'll pass it, but let the matter reach.
Lord.
Only when the matter release.
Lord. Must.
Yes.
I would like to mention one writ petition criminal lordship to be listed under order column lordship, because the on the part of the action and harassment of the police lordship, it was so, 10
Monday.
10 March lordship.
May I please your lordship. Lordship, I beg to mention item number 32, my lord. Today I have some personal difficulty, my lord. 2022 matter, my lord. Kindly pass over the matter for the day. Deeply
If the
obliged.
matter reads, we'll pass the order. Yes.
May I please, your lordship.
10 is Saturday. 10 Saturday.
Sorry, I made it wrong. 11.
May I please, your lordship. I beg to mention item 41, lordship. In this case, lordship, I am led by learned senior lordship P.P. Das, lordship. He has some difficulty today. He is not well, lordship. Therefore, paying for one.
Let the matter reach. Yes.
May I please, your lordship. Item number 9, my lord. In this case, after Corona, my lord, neither the petitioner has contacted us, my lord, nor we could.
Doesn't matter. Let the matter reach. We'll see. Don't worry.
May I please, your lordship, I beg to mention item number 23. The matter may be adjourned for the day.
Okay, let the matter reach.
May I please, your lord, I beg to mention that item number 4, my lord. Matter may be passed over for the day.
Let the matter reach. We'll see. Don't make him anything like it. Let the matter reach.
May I please, your lordship, I beg to mention item number 19. Lordship, engaged counsel has expired. They will engage new counsel.
Who
She will-
expired?
N. Ahmed.
When?
Lordship, 4 months. I think 3 weeks will be given.
Okay, we'll pass the order.
Okay.
We'll pass the order.
May I please, your lordship, I'd like to mention for listing of the matter, lordship, this matter was heard on 7th November 2023, and matter was fixed on 10th November 2023 for or necessary order. That matter is
I
not
remember.
listed.
Give the number. It will come.
Writ petition criminal 23 of 2023.
Right. 23 of 2023.
32 of 2023.
Okay, it will come.
Alright.
May it please your lordship. Lordship, I beg to mention item number 30 of the daily list, lordship. My senior, he has some medical difficulties, lordship.
Okay, let the matter reach.
May it please, your lordships, I beg to mention item number 34 in the admission column, your lordship. Conducting counsel, Mr. Srinath Dekar is unwell, your lordship. May kindly allow
These
the
are the matters where probably the records haven't come or records haven't been called for. So we'll take up the matter, but finally will not dispose of. Don't worry. You'll be here for some time.
much obliged.
If I may please, your lordship, I beg to mention item number 11. Due to certain medical grounds, my senior won't be able to take up the matter. The matter may be adjourned for a week.
Okay, let the matter reach.
May I please, your lordship.
Maybe. This is an expert order. You should probably call for the record and an expert was
Verma, any information?
Lordship,
We call for the records on 22nd of January.
we do not have any information. Item 3, 22nd January. Lordship, where we directed to produce the records.
This is from Borpeta. Mr. G. Sharma.
Check
drafted the
your
order of
No. Lordship, after some time,
Will he come today?
Yes, let me check it out.
We'll pass the order.
Then we'll at 2 p.m. Otherwise, some many,
Okay, we'll have it at 2 o'clock.
yeah, 2 yes, will be better.
My lords, we received the brief after it being filed. So, my lords, we'd like to withdraw the matter because there is some discrepancy in the translation. And we have been engaged after being filed. So, we'll be filing afresh.
What's your good name?
DK Agarwal.
DK.
DK.
D.
DK Agarwal.
D4. DK Agarwal.
Yeah.
Did you file any affidavit?
We have filed a fresh wakalatnama.
When did you file?
We have filed a wakalatnama.
Who are the new councils? You are there, and who else?
I'm sorry, my lords.
Who are the new councils? You are there.
Yes, my lords. Sarfraz Nawaz, AAW Wadood, Miss DK Agarwala, Mr. DK Agarwala, Samim Rahman, Mr. SA Boybuyan.
And Sarfaraz Nawaz.
Yes, and AW Aman.
Heard Mr. DK Agarwal. Also for the petition. Anyone there from the election commission?
Not yet, Lordship.
And Mr. P. My additional general come for the rest. The new set of council, namely AWAM, AW, AMA, Women, Sarfaraz Nawaz, please contact. That's about me, Samir Rahman, and DK Agarwal. I want the appearance in this matter of replacing MS Teacho, Mr. P. Delius. And the name of the new this petition was filed by the petitioner on 10/01/2024. Challenging the order dated 28/08/2023 passed by the Foreigners Tribunal 5th Orang Mongkiroi in F.T.NP capital case number 1992 of 2016, whereby she was declared to be a foreigner under the Foreigners Act 1946. On instruction of the petitioner, Mr. DK Agarwal, learned counsel, please for withdrawal of district petition.
With the liberty to file again.
With the liberty to fight your press as and when press corporate. Right? Petitions are dismissed. Petitions are dismissed. As no liberty as stated.
Much obliged.
May I please, Lordship? Lordship, the petitioner has been declared a foreigner by the order dated 2011-22 by the learned member, Foreigners Tribunal, Murigaon, Lordship. Order is in case 4448, Lordship.
No, don't put the paper on top.
Okay.
It makes noise.
You are Mr. Burua, right?
Yes, Lordship.
Or Mr. M. Burua. Peacefully. Or who is appearing? Mr. Sharma is appearing or Talwar is appearing? Petitioner have felt it's dissatisfied. Morning of something. In M. Dot F. Dot P. Dot will be the and right. He has been declared to be foreigner. The foreigner second and illegally they will be given on or after picking up in the United States.
Obliged, yes.
Register.
May I please, your Lordship?
Not to fix fully allocate by an expert order dated 04/01/2020 in FT case number FT-07-19 and as Furnace Tribunal Court for setup. Declared the petitioner to be a foreigner under the Foreigner Act 1946. Who had entered into state of legal honor of after 25. Filed on 25. Right.
Yes, Lord. Lordship, impugn order is in a case 77. This is a contested matter. The petitioner has been declared as a foreigner of 472.
Petitioner. Two or three, 6 and 7, let's say, were standing up. And 5. Impugn opinion dated 16/12/2020. The direct member for Furnace Tribunal number 1. in application number 822 public G of 16. Point the petitioner, the foreigner and the foreigner petition 6 but illegally entered honorable India bill 25 is satisfied with the same. Petitioner has filed its on 29
My lord, my lord, infill protection.
let the records come. It's
Public.
that's
May please your lordship. May please your lordship. Petitioner. In this case, lordship, petition declare foreigner post of 71 minutes. Just submit the
you are
brutalist.
not 6
Calling for record.
8 3
Then,
developer 5
ভালো ছিল।
in order to 28 opinion. The 21 11 to pathway direct foreigner traffic Corpeta 11 at Sorpo. Corpeta 11. In opinion, appoint the petitioner to get foreigner Miss Verma,
Yes, Lordship.
come to page number 78. The third paragraph, it starts from the record. It appears.
Yes, Lordship. Notice.
On the record. It is the
The 10th line, the left side, it starts with 1946. Got it? 10th line of the third paragraph
Yes,
starts with
Lordship.
1946.
Yes,
On the
Lordship.
left.
Yes,
Kindly read 1946 for deciding
for deciding the question whether O.P. Monawara Begum, wife of so and so, village so and so, was a citizen of India or not, whereupon
but
the,
citizen of India not,
yes,
right? And Derota's method was referred.
yes,
Now come to page number 86, the opinion.
yes, Lordship. could not discharge her burden during the period 77 to 89 after the first entry into sometime before, therefore not in- no, he said that is not true. Therefore they could be regularized as the deemed. Bathroom method.
The reference is affirmative. That means what? Citizen of India or not? That is the reference you have just read.
Mhm. Look, confusing, no? Lordship, since she has failed to establish a linkage and prove her citizenship.
We do not know. You have just read. That is the reason we have seen the third
Yes,
paragraph.
it is contradictory to the first paragraph, last paragraph and the.
Where is the
opinion.
notice?
Notice
You
my
might be having in your record. Just see. That will be there.
notice you have to know NX, my lord.
You didn't get it in your plan.
Reference to next person.
Why it is happening?
Let us get the records, Lordship. The records may reveal otherwise. No, it is clear here. No. Reference has been answered in affirmative for whom?
Call for the record.
State may petitioner.
What kind of opinion? No clarity.
No clarity.
Lordship will take it up on Monday, Lordship. In the meanwhile, we'll also try to find out.
Mr. Hassan, first page of page 77, not here. This is the case number.
77, my lord. Reference FT case number 1524 or 2017.
It is reference IT.
Reference
What is the
number
case number?
10488
And above,
Wha-
that is also reference FT.
Okay.
FT 1524 of the 2017, page 78, my lord.
Next
Top.
page, Lordship
Top,
on
my
top.
lord.
Reference REF FT case number 1524 2017. Decided on 21/11/2023 from the Fairness Tribunal, Assam, Kolkata 11. Call for the-
Lord, some protection will be taken.
The 17 की हो? हाँ? No record person.
16 and 17 are tagged, Lordship.
True, but whether a
Yes.
record of 17 or not, it is the same record. Seventeen no record. Inter record. No. 15, 16,
No,
16, 17, correct.
I mean,
27. Brother of Christopher. records of the application number. FT2nd.
Extremely sorry, my lord, 27, my lord.
From the Foreigners Tribunal Second. Europe. That was disposed of by the same tribunal on 12 days earlier. Of this note, dated 04/01/24 reflect same has not yet. Right. From the constitution as well as the order, the impugn order dated 12/10/2020, it is seen that the reference was initially initiated by Superintendent of Police Border and it was decided by the Foreigners Tribunal Second or ATMO. In view of the special reminder for the records of the second case number 6 Foreigners Tribunal Second, as well as the Superintendent of Police Border around and also Superintendent of Police Border. Twenty-eighth of March. 28th. Call for the case number 5. Foreigners Tribunal March 2nd. My opinion, 14. Border Foreigners Tribunal. List of people it not you petition and like 2000.
May I please lordship? What's a real lordship? Healthcare receipt lordship. Lordship. Today lordship, I have only one humble prayer lordship. Today lordship, I have some matter in item report number 1 lordship. Lordship, it will be clash with that matter lordship. Can it be like any other day lordship? Or it may be taken away, maybe fixed as admission hearing lordship.
Lordship, we had produced the LCR and it is with the court, Lordship.
Tuesday. Today. Lord bless you.
Hmm?
May I please, Your Lordship? My lord, imprint order page number 65, my lord. In this case, my lord, I have submitted 14 numbers of documents, but only one document has been discussed. And my lord, I have been produced 4 witnesses, including my mother and brother, but no discussion about the said evidence. My lord.
So your claim is that your father is Niyat Ali
Niyat Ali.
and mother is Surjo Bhanu. And Niyat Ali is the son. Where is your grandfather is?
Isu
Munshi.
Munshi.
Please take your seat. Yes. Show us your link with your father and your father's link with your grandfather.
Page number 27, my lord.
Hmm.
On 97 photo list, Niyotali, father's name Ishab Muli.
Page number 27.
27, father's name Niyotali,
Hmm.
grandfather's name Ishab Muli.
So that is the link.
Father's link, my lord.
Look at the top. What is written here after annexure C3?
Translated copy of electoral roll.
Now, whether translated copy of electoral roll has any evidentiary value? Nobody has signed it and it is a certified to be true copy. Anyway,
My lord, tribunal has not discussed about.
doesn't matter. That's the law. That's a- To be a certified copy, section 76 of the Evidence Act. Now, whether it is in conformity with the section 76 of the Evidence Act. It is not in conformity with.
My lord, kindly give some time to
What?
see chairman.
Even if it's here, look at it. Now only kept showing. Even the total list of
97.
four, exhibit 3, exhibit 4, the same thing that you have annexed here. There is no difference.
Yes, my lord, same thing. My lord, election officer has signed, my lord, in this document.
Then read section 76. Yeah, but
Certified copy of public document. Every public officer having the custody of a public document which any person has a right to inspect shall give that person no on demand a copy of it on payment of the legal fees thereof, together with a certificate written at the foot of such copy, and it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies so certified shall be called certified copies. My lord, seal and signature is there, my lord.
now your own annexure, page number 32. Number 33, page
32.
number 34.
Yes,
What is the difference between the page number 30, 27 and 32, 33, 30?
these documents, my lord, father-in-law side, my lord, of the petitioner.
Hmm? No, that is, what is the difference between page number 32, 33, 34 and page number 27? We are not asking the names of whose
Yes.
names are there in the voter list.
Yes,
What is the difference?
this difference, my lord, only certified to be true copy.
It is available at page number 32, 33 and 34,
Yes,
and that is not available in page number 27.
yes,
So it's not certified. Translated copy of the electoral roll cannot be a certified copy. So it has to be as per the provisions of section 76 of the evidence. If it is not there, it cannot be considered as a certificate. Okay. Then in this particular year, 1997, for the first time, name of your father figured in the voter list.
no, no, my lord, perhaps their age 39, my lord, Niyatali.
So if the
No.
age of your projected father is 39 in the year 1997, that means his birth year would have been 1958, 1997 minus 39.
Yes,
So if it is 1958 is his birth year, if it was 1958, you add 21 because till 1989 it was 21 years. So if you add 29, it will become 1979. Show us any such voter list that you have placed before the tribunal, showing your father along with other sons or brother or your grandfather in any voter list
my lord,
together at any point of time
my lord,
after 1979 or from 1970.
My lord, after 97, my lord, 2011 photo list is there, my lord. In this
We are
photo list,
asking
my
you
lord, the father's
any,
name is
any voter list prior to 1997, which your projected grandfather, which your uncles, or your projected other uncles of your father.
my lord,
Is there any other voter list to show?
my lord,
Why your name
father,
is the first time included in the voter list of 1997?
no, my lord,
Why
not,
not earlier?
not submitted, my lord. In the photo list, between
Because
1970 and 97.
you have to establish any such. Possibly a person may be young enough whose name is
Yeah.
not entered,
Yes,
but there has to be a voter list somewhere to show your link along with the other uncles. That means other brothers of Isu Munshi. What happened? It is there.
my lord, can it be given some time to produce
You cannot produce it before this court
a-
at this stage.
additional,
Whether
additional
you have
document?
produced before the tribunal or not.
No, my lord.
Then how you have proved the link?
Then, my
Your
lord,
link with Niotali and your link with Niotali's link with grandfather Bishop Munshi. This voter list of 97 only,
yes,
along with one Surjavanu. How will you say that? You have to prove it. Have you mentioned the name of your brothers and sisters in your reply, your so-called reply? That is written statement.
in written statement, my lord, not mentioned, my lord. In evidence,
Can
my lord,
you- That's the
evidence,
reason we are asking you. Can you go beyond the pleadings?
my lord, I have mentioned in evidence, my lord.
True. Without mentioning it in your written statement, can you mention it in your evidence? Can you go beyond pleading? Show us that you can go beyond pleading. How you have proved? How you have proved your link? Now come to the certificate issued by the Gaunpura. Page number 35.
35.
First of all, it has the national emblem, right?
Yes,
Then read the contents.
certified to Mr. SMT Bahator Nessa, wife of Johor, village Kudrokhua, post office Ishabpur, Mauza Titapani, PS Kolgasia district, Borpara, Assam.
Just a minute. So, he is the Gaunpura of your
Kudrokhua,
village of your husband. That means your in-laws house, right?
yes,
Then
my lord,
there is the next correction.
my lord,
She is Same page, page 35. Kindly read.
She was an inhabitant under our 19 number search area. The name of her own father, mother, husband, grandmother's name was listed in the electoral roll 2017 as scheduled below, shown below. Name of constituency 44, number Zonia LSC, house number 184, serial number 1022, part number 103. Noted that the woman married with.
So how it is linked with your father, Niyat Ali?
Mm.
Is it there anything?
No, my lord.
Next, you come to page number 36.
36.
There is a state emblem, national emblem is there,
Yes, my lord.
then it is government of Assam.
Yes.
Now a Gaon Panchayat can be a government of Assam. So the Gaon Panchayat can be a government of Assam. Anyway, read the contents.
This is to certify that Bahadur Nasa, daughter of Niyat Ali, village Nararvita part 2, post office Nararvita PS Meresor, district Bongaigaon, Assam, is an inhabitant of the said address.
It describes only about an inhabitant
Inhabitant,
and daughter of Niyat Ali.
Niyat Ali.
What is her age?
Is not mentioned, my lord.
It is mentioned. Read properly.
Only here mentioned, my lord, she has married with Zoharuddin, son of.
Above that, he is oblique, her age is.
Yes, no, not mentioned, my lord.
Why not meant? It's available in our annexes. It's not available in your annexes. In our annexes, it is available. It took his work. X and 1. 11 years old. Verify from the original. It is your document only.
My lord, not 11 years, my lord, it is Kachin, my lord.
Then, along with the cross scene, what is it?
Crossing.
By the side of the cross scene. Okay, let us assume it is cross. Then what is by the side of the cross? Now, come to Page number 55. Read the evidence of
Since 6/6/2014, I had been working as a secretary of Rangapani Gao Panchayat till 2/12/2016. At present, I am the secretary of Pasania Koragao Gao Panchayat, district Bongaigaon. OP had applied for issuance of a certificate. Accordingly, I have issued the said certificate.
then in cross.
There are 8 villages under Rangapani Gao Panchayat. I personally do not know OP.
So wherefrom he has given this statement. So you tell us how you have proved it, that you are the daughter of Neotali and Neotali is the son of one Munshi, whose name figured in the voter list of 1966 and 7.
My lord, page number 37, my lord.
Page number 30.
Chittagong.
Yes.
Column number 7.
Hmm.
Neotali, son of Ishab Munshi.
Hmm.
And my lord, serial number 4, Bahatur Nesa, daughter of Neotali.
By producing this Jamabandi, this is a Sita copy, not even Jamabandi.
Chittagong.
What is the value of this in the evidence?
My lord, on the issue in Anjana Mr. judgment discussed the said issue, my lord.
Which case?
Anjana Bishar.
Anjana Mishra. Can you give us the citation?
My lord, para number 103, my lord. A exhibit A is the school certificate issued by the head teacher of Ondulpota Muragasa Primary School, Nadia. However, nobody was examined on behalf of the said school, and as such, though the said school certificate was exhibited, since is not proved as per law, the observation of the learned tribunal that it cannot be relied upon cannot faulted. However, we would also like to observe that the state tribunal has not questioned the genuineness of the said document, though the requirement of law is that a document can be said to be have been proved only when the author of the document is examined. Yet, in the present case, what we have noted is that the said document was never questioned nor doubted by the state, because of which the said document cannot be totally ignored. My lord, at the time of exhibit, my lord, the respondent said not disputed, my lord, about the said document.
Where you have stated in your written statement that your father has land property. Which paragraph on your written statement?
W. W. My lord, in WS, my lord, has not mentioned, my lord. Only land records mentioned.
Hmm.
In WS, para number 13, my lord. Yes.
So what is the submission?
My lord, one more submission, my lord. In this judgment, my lord, para number 78,
Which judgment?
my lord, Anjana বিশ্বাস. In this regard, before we examine the evidence of the petitioner, 78, my lord, para number. We examine the evidence of the petitioner herself. We will examine the evidence of Onil বিশ্বাস, the projected father of the petitioner, who was examined as DW3. As per the original records of the tribunal, which are before us, Onil বিশ্বাস was aged about 74 years when he appeared before the tribunal. He gave his particulars as the son of late Khudiram বিশ্বাস, a Hindu residing in village Palda, Marugasa, police station Katwali, district Nadia, West Bengal. He accordingly stated in his examination in chief that the name of his father is late Khudiram বিশ্বাস, and he was born and brought up in village Palda, Muragasa, and presently residing there. He also stated that he got married in Palsa, Muragasa village, and the name of his wife is Anna বিশ্বাস, and she is still alive. He stated that he has three children, namely Tapan Vishwas, Tapos Vishwas, and Anjana Vishwas. He categorically stated before the tribunal that the lady standing on the dock is Anjana Vishwas. His daughter, he stated that Anjana Vishwas was born and brought up in village Palda, Muragassa, purchased lands prior to 1974, and the land documents have been submitted by his daughter before the tribunal. He stated that he cast his first vote in the year 1970-71, and his daughter submitted a certified copy of the voter list. He also stated that his daughter was married 18 years ago to one Ratan Sarkar of village called Khandanjan of Morigao district, and his daughter has two children. He stated that Anjana Vishwas is not a foreigner. He stated that he being born in village Palda Muragassa is an Indian. The said Onel Vishwas DW3 was questioned by the tribunal under section 165 of Evidence Act 1872. It may be noted the state which doubted the citizenship of the proceedee did not put any question to him about his claim of being the father of the proceedee. The answers given by the said Onel Vishwas to the questions put by the tribunal are reproduced herein below. I cannot tell my date of birth. I cannot tell the date of birth of Anjana Vishwas. She is 40 years of age. I purchased land at price rupees 200, land measuring 12 lessa. I purchased land at village Palda, Muragassa. My lord, in the present case, mother deposed, my lord. No question has been put by the respondent, my lord. My lord, para number 79, my lord. We have noted that apart from inquiring about the date of birth of the said Onel Vishwas and the proceeding, no question was asked to doubt the claim of the said Onel Vishwas, and he is the father of the petitioner. In fact, no other question was asked to Onel Vishwas. Next, my lord, para number 81. From the evidence of Onel Vishwas examined as DW3, it comes out very clearly that DW3 Onel Vishwas had come all the way from West Bengal to Morigao in Assam to testify in favor of the proceeding petitioner. The learned tribunal has, however, cast serious doubt on the credibility and genuineness of the said Onel Vishwas by making a very accurate comment that Onel Vishwas is an interested witness and had been tutored by the proceedee, and the proceedee had used a false genealogy and used somebody else legacy to prove her citizenship of India. We utterly fail to understand how the learned tribunal came to such an adverse finding without any evidence that Onel Vishwas is an interested witness and had been tutored by the proceedee, and that the proceedee had used the false genealogy. For arriving at such a conclusion, the tribunal appears to have been swayed by the fact that the proceedee did not mention the name of her mother in the written statement. The learned tribunal also appears to have been influenced by the inability of the said Onel Vishwas to state his own date of birth as well as of the proceeding. Anjana Vishwas, which according to the tribunal cast a serious doubt that he is the father of the proceeding.
So how this helps you?
My lord,
How this doesn't help you?
my lord, in the present case, my lord, mother deposed before the tribunal in favor of the petitioner, respondent has not put any question, my lord. That is, that means, my lord, he's admitted my claim, my lord.
That you are the daughter of,
I am the daughter of Niyat Ali.
so as that Niyat Ali is son of the person whose name figured in the voter list of 1966 and 19.
My lord, my lord, 37 Sita copy, my lord. Connection.
Read. When
My-
the order was passed,
My lord, 11/11/2000.
when the order was passed in the city.
1/11/11/2017.
Hmm.
And as per order dated 11/11/2017 of the circle officer passed in
Hmm.
mutation number so and so,
Hmm.
the name of Niyat Ali, son of Isab Munshi,
Hmm.
and Aman Ali, son of Isab Munshi, has been mutated in place of Isab Munshi as legal here.
Hmm.
Next, my lord, as per order dated 2011/2017
Hmm.
of the circle officer passed in mutation number so and so, the name of Bahatun Nessa, daughter of Niyat Ali, Saizuddin, son of Niyat Ali, Aizuddin, son of Niyat Ali, Shazadul Islam, son of Niyat Ali, Shahida Khatun, daughter of Niyat Ali, Rashida Khatun, daughter of Niyat Ali, Zahidul Islam, son of Niyat Ali, Shaziran Khatun, daughter of Niyat Ali, Asadul Islam, son of Niyat Ali, and Mazuni Khatun, daughter of Niyat Ali, has been mutated in place of Niyat Ali as legal heirs. This is only linkage, my lord.
Now, whose name figured in the voter list of 1997?
My lord,
Whose name figured in the voter list of 1997?
my lord, Niyat Ali is my father, Isab Munshi my grandfather, Fuzabhanu my mother.
When the name of Isab Munshi figured in the voter list? Because this voter list of 97.
My lord, 66. My lord, page number 24, Isab Munshi.
What is the name of the person named figured therein?
Isu Munshi.
Wherefrom you are making that Isu Munshi and Isab Munshi is the same person?
Yes, my lord, some discrepancy is there, my lord. In Sirajul Haq case, my lord, consider the name of.
Read Sirajul Haq and make statement.
My lord, Sirajul Haq is not
Read paragraph
there,
3.
my lord.
Read paragraph 3 of the Sirajul Haq and make
My lord,
statement.
Sirajul Haq is not there, my lord. Motiur Rahman is there, my lord.
Read it. Motiur Rahman is deciding it is Sirajul Haq, right? Read para 3 of Sirajul Haq or Motiur Rahman.
Para 11, my lord. We also find from the record that the learned tribunal has declared the petitioner as a foreigner based on some minor discrepancies in regarding of age and also for non-mentioning of the date of second marriage of the father of the petitioner. However, such discrepancies, in our opinion, are minor in nature and hence, even if found correct, would not have any material bearing in the outcome of this writ petition. Moreover, in the decision of the Honorable Supreme Court rendered in a case of Sirajul Haq versus State of Assam in connection with the criminal appeal number so arising out of SLP number so it has been held that minor discrepancies in regarding of names, age, and address of the family members of the proceeding cannot be down to doubt his case.
Right?
Yes.
Sirajul Haq. Read that judgment, Munwara, whether the Supreme Court has seen that or we find out from the paragraph 3 of that.
In Monwara,
The judgment you have just read. This is Munwara, right?
no, my lord.
This is
This is my Motiur Rahman.
Motiur. See the difference, what the Honorable Apex Court has said in Sirajul Haq and what this court has said following the Motiur. Where is the difference? That's When a law or a decision is placed by the appellate court, the High Court will definitely,
Yes, my lord.
definitely cannot go beyond the decision of the,
Yes, my lord. Yes.
but there cannot be any alteration of the decision of the Supreme Court of,
Yes, my lord.
right?
Yes, yes.
See the twist and turn in that.
Okay, my
Yes.
I was referring to Manawara and
Because the voter list, you have to accept as a whole,
Sapphire.
because the voter list you are placing, you cannot pick and choose something from the voter list. And therein what the Honorable Appellate Court, in what context the Sirazul Haq decision.
Boran.
Just
Boran.
you have to pick up a line. Decision. In
Okay,
what
well.
context the Appellate Court has been.
Okay, my lord.
Sirazul Haq decision is- SPP.
Manawara. Voters.
Read it very carefully from the very first paragraph. In what context the Honorable Appellate Court has stated. Read from para one.
Having said that, we may look into the written statement filed by the
No,
petitioner.
this is para one. Paragraph one of the Sirazul Haq.
Paragraph 1.
Ms. Verma, right. Oh, the territory paragraph three is there.
Three
Yes, my
lordship.
lord. 3 is there.
One is leave granted, lordship. One is the leave granted, the present appeal raises. It is from the or having said that we may look into the written statement.
This is para three or para,
Nothing mentioned, but the second one is para 2 and 3. One is not written, but one is supposed to be that. The High Court dismissed the writ petition filed against
okay, let
the
it start. Let him read it.
The High Court dismissed the writ petition filed against the same judgment stating Sirajul Haq case. Having said that, we may look into the written statement filed by the petitioner before the tribunal. In a proceeding before the foreigners tribunal where the citizenship status of the petitioner is being questioned, that too by the state, the proceeding must disclose all material facts within his special knowledge relevant for establishing his citizenship at the first instance itself, that is in the written statement. In other words, he must be able to plead about his identity as a citizenship of India. This would be as per the requirement of the Section 9 of the Foreigners Act 1946, which is in peri materia to the provision of Section 106 of the Evidence Act. Thereafter, the material facts pleaded in the written statement are required to be proved in accordance with law by adducing cogent and reliable evidence. In the written statement, the petitioner did not even mention his name, not to speak of his date of birth or year of birth. All that he stated was that he was born at village Sagolsera in the district of Dhubri, and that his parents were voter list in the voter list of 97. His grandparents were voters of 1966 to 1970. Only in the verification column, he described his name as Sirajul Haq. This is all that the petitioner stated in the written statement. This is not only inadequate but does not in any manner lead to the identification of the petitioner as an individual, not to speak or of identification of the petitioner as a citizen of India. It is not a case of violation of principle of natural justice or procedural impropriety. Neither can it be said to be a case of perversity. We have heard the learned counsel for both sides extensively and have gone through the documents produced by the appellant ourselves. On a perusal of the same, we find that a number of documents have been relied upon by the appellant, stating with a voters list of his grandfather Kematullah in village Sotobas Ganji, Gani. There is no doubt that the great grandfather's name Amtullah appears as Amtullah through the document. Equally, there is no doubt about the father's name, which appears as Hakim Ali throughout. The only discrepancy found is that in some of the documents, Kefatullah later becomes Kematullah. However, what is important to note is that his father's name, Amtullah, continues as Amtullah, and the other family members associated continued as such. Also, produced are NRC registration details of the year 1971 of the grandfather, who is noted to be Kefatullah in this document. Other voters list are then produced, where the letter F becomes the letter M, with other family names remaining the same. In fact, the appellant has himself produced a document of 1981 from the Income Tax Department giving his permanent account number. Apart from these documents, certain other documents have also been produced, including photo identity cards issued by the Election Commission of India and identity cards issued to his brother, including voters list in which the appellant's name appears. Having gone through these documents, we are of the view that it is not possible to state that Kematullah is not the same despite being named Kefatullah in some of the documents. This being so, the grandfather's identity, father's identity, etc., has been established successfully by the appellant. Further, the mere fact that the father may later have gone to another village is no reason to doubt this document. We therefore set aside the judgment of the High Court as well as the Foreigners Tribunal and allow the appeal. As a result thereof, the appellant is liable to be set free at once.
Now, the judgment that we have just read prior to this, that is Sirajul Haq has been considered. Whether the Sirajul Haq, the Honorable Apex Court has said anything,
No.
but in the judgment that is you have read is Manuara. What is that?
Motiur Rahman.
What do you? See the difference? There is no term.
We also find from the record that the Learned Tribunal has declared the petitioner as a foreigner based on some minor discrepancies in recording of age and also for non-mentioning of the date of second marriage of the father of the petitioner. However, such discrepancies, in our opinion, are minor in nature and hence, even if found correct, would not have any material bearing in the outcome of this writ petition. Moreover, in the decision of the Honorable Supreme Court rendered in the case of Sirajul Haq, in connection with the criminal appeal so arising out of so, it has been held that minor discrepancies in recording of names as and address of the family members of the proceeding cannot be ground to doubt his case.
Please give us this Sirajul Haq.
The discrepancy
There
of
is no scope of interpretation of this particular judgment of the Honorable Apex Court. The Honorable Apex Court verified and what they found. The Honorable, their lordships have found certain things in that case. The first is, though only one particular letter in the name of grandfather, instead of Kefatullah, it has become Kematullah. F substituted by M. But more important factor, what the Honorable Apex Court found is that the father's name, Amatullah, continues as Amatullah. And the other family members associated continued as such. Right?
Yes.
So in that particular case, the voter list that were placed before the tribunal, which was also been upheld by the Honorable High Court at that point of time. This Kefatullah was the name as the grandfather. His name was there along with name of the father of the proceeding and other relatives of father of the proceeding or the proceeding. All remain intact. Only one letter in the name of grandfather, Kefatullah, has become Kematullah, have been replaced by Kematullah. Since the names of the other voters found intact in the voter list of say 66, 70 and thereafter up to 1997, there was no other any mistake excepting name of the grandfather. In that context, the Honorable Apex Court has clearly said that it has to be accepted because here only the later word Kefatullah has become Kematullah. The other factors remain intact. Name of the father, name of the other voters that found it throughout it remained the same. In that circumstances, the Honorable Apex Court has said so. The minor discrepancies, the Honorable Apex Court never said. So how will you show us that the name of your father figured along with others in the voter list at any point of time whose names figured in the year 1966 and 1970.
My lord, no other photo list, but my lord, tribunal has not finding any discrepancy in name, age, and age.
Is
My
it
lord,
required?
my lord,
Is it required? Is it required?
my lord, tribunal has not discussed all document and evidence, my lord.
Okay.
This is my
Relying on
submission.
This Anjana Biswas, paragraph 78, then 79, then 100 and
My lord.
2,
81,
81,
100,
100
103.
and 10. Oh. Anything else?
No, my lord. This is my submission, my lord.
Also give us that citation,
My lord.
that other case you have.
Yes, my lord. Motiur Rahman, 2021 GLT.
Just it. 2000,
2021 GLT 330.
yes. Will reply.
Lordship, I'm replying.
How will you defend Anjana Biswas?
Can I have the judgment of?
You take it. How will you defend Anjana? Is there any finding?
Yes, Lordship.
The judgment passed earlier, the Honorable Appellate Court clearly state that under the Foreigners Act, read section 9 of the code.
Section B. Burden, Lordship. Burden of proof. Section 9, Lordship of the Foreigners Act 1946. If in any case not falling under Section 8, any question arises with reference to this act or any order made or direction given thereunder, whether any person is or is not a foreigner or is not a foreigner of a particular class or this description, the onus of proving that such person is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall, notwithstanding anything contained in the Indian Evidence Act 1872, lie upon such a person.
So, as per this provision, whether the burden shifts to any person to prove the proceedee is a foreigner?
No.
As per this provision, whether the tribunal, if doesn't make any inquiry to the proceedee or his or her witness, if the burden doesn't shift, will amount to say that if any queries is made and certain queries are not made by the tribunal,
Yes, Lordship.
will it be the amounting to the proof that the
No.
proceedee is a foreigner, is not a foreigner?
No.
How do you explain section 9 of the Foreigners Act?
Section 9, Lordship, the onus is on the proceedee to prove that he's a citizen by way of
What is the
documents.
decision of this honorable, the honorable apex court? Because only
not.
when it is said may,
Yes, Lordship.
so that doesn't. There is a decision to what
Or
extent.
Ghaus Mohammed, Lordship. My representative is Sarpan.
Constitution bench judgment.
Yes.
Can you interpret the constitution bench judgment in that way? That if the tribunal is silent, it amounts to acceptance of the.
No, Lordship, we have a judgment of this court also to that effect, which I was about to refer. May I place it, Lordship, to the same proposition which Lordship is referring to?
Hmm.
It is WPC 2641 of 2017, Lordship.
Hmm.
It is the state had filed State of Assam versus Ohab Ali, and it was decided on 29/5/2018.
20,
29/5/2018.
has it been challenged before the honorable apex court any point of time?
No, Lordship, not yet. Lordship, may I?
Just a minute. हेरिटू करने का वो लोग
Lordship's queries would
Just-
find their reply here, Lordship.
Yes, fine. It's very good. It's very good.
Has Lordship found it?
Just a minute. Brother, can you read? Yeah. You.
Paragraph 13, if Lordship has found it.
Just a minute. Trying to. Okay, let's go like it. Yes, please read, ma'am.
Paragraph 13, Lordship, may I take Lordship to paragraph 13? Though petitioner exhibited a number of documents from exhibits A to M, we find that none of these documents were proved in accordance with law. They were simply filed and marked as exhibits. It is tried that mere filing of document or marking of document as exhibit is not enough. Not only the document has to be proved, the contents of the document would also have to be proved. That apart, truthfulness of the contents would have to be proved too. The two crucial documents. Lordship, we can skip that and come to paragraph 16, Lordship. On the other hand, from the impugned order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in State of Assam versus Muslim Mandal, so and so. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and thus burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the facts in issue. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevance, it cannot be said that the proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance. This would be the reply to what my friend is saying, that there was no rebuttal from the side of the state, Lordship. Then, Lordship, we would again like to rely on the voters list, which are not the certified copies. Translated copies of voters list, which my friend has annexed to the writ petition, Lordships. We would like to rely on WPC 2460 of 2016, Lordship, decided on 10/4/2018. Isiran Nessa, ISIRAN NESSA. Lordship, this deals with the proposition of the translated copy of voters list as per section 63. First, Lordship, it takes up section 65, section 63, 65, and 74, Lordship, and as well as section 76 of the Evidence Act.
Kindly repeat.
First,
Sections.
yes, the proposition here is, Lordship, question for consideration is
Kindly
whether,
repeat the sections of the Evidence Act.
I will, Lordship, section 71.
Hmm.
First is section 61,
Hmm.
62, 63, 65, and 74 and 76. It's the same proposition which Lordship has taken up. Question for consideration is whether a translated copy of electoral roll can be construed as an admissible piece of evidence. Further question is whether translated copy can be considered as a certified copy and thus an admissible piece of evidence.
Directly use करना जाए आपको काटियो ले itu next ডাউনলোড দিলে চাব নহলে কাটি যাব ডাইরেক্ট Which is the order?
Lordship has found it.
This is 2640/2016.
2460
460.
of 2016.
Yes.
Lordship will come to, since it's not paragraphs are not there, Lordship. I'm reading from Lordship. One, two. I think I start from Lordship. Question for consideration is whether it is, or Lordship may come to firstly
Got it.
petitioner.
Question is when according to.
Yes, Lordship. Question for consideration is whether a translated copy of electoral roll can be construed as an admissible piece of evidence. Further question is whether translated copy can be considered as a certified copy and thus an admissible piece of evidence. Black's Law Dictionary 6th edition has defined certified copy to mean a copy of a document or a record signed and certified as a true copy by the officer to whose custody the original is entrusted. Section 61 of the Indian Evidence Act deals with proof of contents of documents. Contents of documents may be proved either by primary evidence or by secondary evidence. While primary evidence is explained in Section 62, Section 63 deals with the secondary evidence. As per Section 63, secondary evidence means and includes certified copies, copies made from the original by mechanical process, ensuring accuracy of the copy, and copies compared with the original. Copies made from or compared with the original, etc. Section 65 deals with cases in which secondary evidence relating to documents may be given. It says that secondary evidence may be given of the existence, condition, or contents of a document in the cases mentioned therein from clauses so and so. Secondary evidence may be given when the original is a public document within the meaning of Section 74. Section 74 explains as to what are public documents, and Section 76 deals with certified copies of public documents. As per Section 76, every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees thereof, together with a certificate written at the foot of such copy that it is a true copy of such document or part thereof, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal. Such copies so certified shall be called certified copies. On a careful reading, Lordship can, on a careful and conjoint reading of the aforesaid provisions of the Evidence Act together with the definition of certified copy, we are of the unhesitant view that a translated copy such as Exhibits A and D cannot be construed as certified copies and therefore cannot be treated as secondary evidence. This position is further strengthened if we look at the exhibits of my friend Lordship, because there is no certification by the competent authority certifying that the extract are true copies from the original. We may also observe that though certified copies are admissible as secondary evidence, it would be so only if those are issued by the competent authority. Admission of photostat copies, even if attested by notary public, is improper and inadmissible in evidence under Section 63 of the Evidence Act. That apart, certified copies of documents, not to speak of photostat copies, not coming within the ambit of Clause A or E of Section 65 would not be admissible in evidence. that apart as a general principle, secondary evidence is not admissible until non-production of primary evidence is satisfactorily accounted for. In addition, we may also refer to Section 66 of the Evidence Act, as per which secondary evidence of the contents of document shall not be given unless the party proposing to give such secondary evidence had previously given to the party in whose possession or power the document is such notice to produce it as is prescribed by law. In other words, a party desirous of adducing secondary evidence must not only satisfactorily explain non-production of primary evidence, but also must give previous notice to the party who is in possession of the primary evidence. And if despite such notice, the primary evidence is not produced before the tribunal by the custodian of the primary evidence, in such a situation, tribunal may invoke its power under Order 4 of the Foreigners Tribunal Order 1964 to issue summons to the custodian of the primary evidence. So, Lordship, the translated copies cannot be taken as an admissible piece of evidence. And to that, we have relied to this judgment, Lordship. Next, I would like to rely on is the Gaubura certificate, Lordship.
Camera not examined. That
Not
document
examined, and even the state emblem is there, Lordship. And proving of land documents. If he's relying to the land documents, my humble submission would be the order shows name of all the siblings and the complete family, but in the WS, nothing is
This
shown.
is a CITA copy, it's not a certified copy.
It is not a certified copy, Lordship. And even the Gaon Panchayat certificate, Lordship. Gaon Panchayat certificate has Government of Assam written on it. And for that, I would like to rely on one of the judgments.
Just a minute.
Kudeja Khatun, na ito? 7753.
Please take your seat for a while. Okay. Yes, please proceed. Yes.
Now, Panchayat certificate, Government of Assam is written. So
Hmm.
I'm relying on WPC 7756 of 2016. Decided on 26/4/2018.
Just a minute.
Doctor negotiated.
First of all, you said that state emblem.
State emblem, Lordship.
Yes.
State emblem I would refer to. This is a state emblem, Gaubura certificate, state emblem and contemporaneous records. For this, I'm relying on WPC 6283
Hmm.
of 2016, decided on 22/5/2018. Sajida Khatun, Lordship.
SAJD.
SAJEDA. Sajida Khatun, KHATUN. Paragraph 24, 24.1 and 24.2. Then for the Gao Panchayat certificate and Government of Assam written lordship, this is WPC 7756 of 2016.
7756.
Yes, lordship.
2000.
16. Decided on 26/4/2018.
2406 2018.
Yes, lordship. Khudeja Khatun, KHUDEJA. KHATUN, Khudeja Khatun. Paragraph 15 and 15.1.
Yes.
Lordship, for section 9, I would even like to rely on a Supreme Court judgment, Lordship. Union of India versus others, Ghaus Mohammed.
Yes. AIR.
AIR, Lordship. 1962, 1 SCR 744.
1962.
And Lordship can take up the AIR 1, AIR 1961, SC 1526. We have a copy, Lordship.
1526.
Yes, Lordship. Paragraph 6, Lordship.
1962 or 61?
Lordship, if it is AIR 1961
Yes.
SC 1526.
Yes.
Paragraph 6, Lordship,
This is the
section.
Constitution Bench judgment. Yes.
Yes, Lordship. Section 9 of this act is the one that is relevant. That section, so far as its material, is in these terms. 9. If in any case not falling under section 8, any question arises with reference to this act or any order made or direction given thereunder, whether any person is or is not a foreigner, the onus of proving that such person is not a foreigner shall, notwithstanding anything contained in the Indian Evidence Act 1872, lie upon such person. It is quite clear that this section applies to the present case, and the onus of showing that he is not a foreigner was upon the respondent. The High Court entirely overlooked the provisions of this section and misdirected itself as to the question that arose for decision. It does not seem to have realized that the burden of proving that he was not a foreigner was on the respondent and appears to have placed that burden on the union. This was a wholly wrong approach to the question. Relying on this paragraph, Lordship. And this appeal was filed by the union, Lordship.
Yep.
That's
Right.
all.
There is one judgment
Yes, Lordship.
by the apex court subsequent to this. There is, what is? Here it was observed that what May was there.
Sorry, Lordship.
May was there regarding the evidence to be
Me,
adduced by the proceeding.
proceed.
When it can by the government. Only when it will shift, there is a judgment of the division bench. Our High Court.
When the burden will shift. Yes, I will look into it, Lordship.
But anyway, this is the Constitution bench judgment. It doesn't shift. Anyway,
I had read out that the burden does not shift in my first citation, Lordship.
no, there is a Supreme Court judgment also.
We'll find that out, Lordship.
State of Assam, Oheb Ali.
Yes.
Huh?
Yes.
State of
I
Assam,
guess-
Oheb Ali said.
Oh, hey, Bali, the one which I just read. Here also, Lordship, it has been observed. Para 16. The first one, State of Assam versus
Para
Ohab.
16 we have
Yes,
noted.
Lordship,
You said para 13 and 16.
13 and 16, Lordship.
Mr. Hussain,
My lord,
the records reveal
my lord,
a petition was filed. The record as well from the record we are saying
my lord.
on 6th of February 2020. For further evidence. after the examination of the Gram Panchayat secretary. So the petitioner filed a petition on 6th of February stating that evidence of the Latmandal
Yes,
for proving the exhibit number 12 Sitha of the concerned servant village is necessary and summon to be issued to the concerned Latman.
yes,
The tribunal on 6th of February 2020
yes,
passed an order kindly listen to the order. OP is present in person along with engaged counsel and witness. Government advocate represents state. Examination in chief of DW3, that is the secretary of the
Yes.
government, is taken down. DW3 has been cross-examined by the state. OP has filed a petition praying for issuance of summon to the Latmandal.
Yes.
Petition number 14,416 is allowed,
yes,
directing engaged counsel to take steps immediately for issuance of summon.
Hmm.
Fixed 17/04/2020 for further evidence. Petitioner did not take any step for issuing summon, though the tribunal passed an order. Did not take any step for issuance of summon to the Latman. Instead of that, by filing a subsequent petition, they have adduced the evidence of DW4. That is the
brother,
projected brother of the process.
Yeah.
This exhibit 12, as apparently here is a photocopy. It has not been proved by any other authority. So in that circumstances, when this exhibit 12 land document has not been proved by the proceeding in spite of granting of chance by the tribunal or been allowed by the tribunal, how you will able to show that you are the daughter of Niyat Ali? Because that document hasn't been proved.
my lord, documentary, my lord, only this document, my lord.
We have seen
Yes, my lord.
instead of producing the Latmandal, it was the petition was allowed by the tribunal. But
Yes,
the proceeding did not take any step
Hmm.
for issuance of the concerned Latmandal. Now, instead of that Latmandal was supposed to be there for the proceeding has reduced the evidence of
AW4.
her protected trust.
Yes.
That document remain without being proved. So what will happen?
My lord,
No,
Okay.
your entire basis is two. That is 1997 voter list and the land document.
Hmm.
The land document goes because it not been proved.
Hmm.
Then the 1997 voter list that you have added goes because it's a translated copy. You have also seen at page 32, 30, 34 regarding the
Other copies.
translated copy of voter list, but certified to be.
Hmm.
But here he is in page 27 in your repetition, that is the 1997 voter list. It's not a certified copy.
my lord, another aspect, my lord, in the impugned judgment, my lord, I have produced 4 witnesses, including my mother and brother. That is not discussed, my lord.
True.
My
That
lord,
is what
another, my lord, I
You-
have,
what is the what the court is looking for? How you have proved that you are the daughter of Niyat Ali, and the Niyat Ali is the son of a person named Isu Munshi, whose name figured in the voter list of 1966 and 1970. Had there been any document or any voter list of
my lord,
Isu Munshi, Nasir Sheikh, Tasir Ali, all are the brothers of your father, your grandfather, right? So along with them, had there been the name of the your projected father Niyat Ali at any point of time, considering the decision of the Honorable Supreme Court in the case of Sirajul Haq,
Hmm.
you could have proved that link. Where is that link now?
My lord, exhibit 12 is exhibited by the tribunal, my lord. My lord, respondent side has not rebutted any evidence, my lord.
The Constitution bench judgment is very clear. It has to be
Yeah.
such an evidence, acceptable evidence.
Admissible.
By mere producing a document without being proved, how will you able to prove it as a evidence in your any document you can bring? Photo state copy. This is also a photo state copy. It has not been proved by anyone. It's not even certified copy.
Yes.
Anything else you'd like to submit?
No, my lord.
Yes, we wanted to know from your case, Anjana Biswas, Motiur Rahman,
His lordship.
what is your stand?
I don't know the-
Though the apex court has said something, though the Sirajul has said something, we have seen Motiur Rahman is something different
Yes,
and Anjana Biswas is something different.
completely different lordship, not taking into consideration the earlier judgments of the apex court and this court.
We do not
lordship.
know, it is up to you. We didn't know this Motiur Rahman and Anjana Biswas. Of course, we did not read, that is why now we have read, came to know. What will happen to the decision of the Constitution bench judgment of this Honorable Apex Court in the case of Union of India and Ghost Mohammed? What will happen to Sirajul Haq? If that is the case, if the Anjana Biswas stands or Motiur Rahman stands. You are also silent. Why?
Lordship.
Why you are silent? Your state.
Lordship, we had also placed our stand, but that was not taken into. Our stand was also there, lordship,
No, maybe,
but.
maybe council
the
may not
court
be
had
aware.
its own view
But
and
thing is
took up a
this,
different view completely.
but subsequently these are the judgments of the Honorable Apex Court, which will prevail.
Definitely the apex court judgments would prevail, lordship.
Give us Anjana Biswas.
My lord, in Anjana Biswas case, my lord, para number 1 and 2,
112.
1 and 2,
Yes.
1 and 113,
Earlier you said, we'll just note it on everything here. Your 11 paragraphs were 78, 79, 81,
yes, my lord, 78, 79, 81,
10, 100, then 103.
100, 103,
Now 112.
112, and 113 and 114.
Okay. We'll consider it.
Yes, my lord.
Heard, Mr. M. Counsel for the petition. and MSA Verma Standing Counsel from Department for the respondent. To also heard Mr. P. Sharma, Additional Senior Government Assam for the respondent. And fully for a there is the record that was called for. By order dated 1901. Hearing concluded.
My lord, one prayer, my lord. Can it be adjourned in item 21, my lord, for the day, my lord?
We may not reach to that extent. Forty-six.
Most obliged.
We have seen the file and it was communicated to the Chief Judicial Magistrate on 13th of February only. So we'll wait for some time. And unofficially, it is not through the records, but we have also inquired what is the status. In many districts, what is happening, large number of such cases where FR has been filed are pending. We've been working out to all these things. In Guwahati, there is a difficulty. They have demolished the earlier building. They have dumped it in a particular office, particular room in a Ganime, not seasonal. So there are the instructions through the district and session judge. This is here to first check out all the records year-wise, because it is not possible to find out there is no record. Just dump it in gunny bags and just shift it to another. So they are doing it, of course, immediately it is not possible, but they will take out this. Only after taking out this, we have asked them to do it still by year-wise, month-wise. So thereafter you will get, because this is the report of 2017, so you have to wait. And in fact, it is, I've been told unofficially it is prior to that. It's just lying down. In fact, frankly speaking, earlier there was, we have district-wise zonal conferences. So when His Lordship Justice Ajit Singh sir was there, we had such zonal conferences in various processes, even at Valpara, at Tejpur. There, these things were discussed, and it was directed. Decision was taken that way, that how they have to do it. Somehow, after COVID, it boomerang. So we fix it in the later part of April, getting it, right? Give us a date that should be
Any date convenient for you.
25th. Let it be on 25th of April. Issue fresh reminder, just right. Peruse the office note dated 13/2/2024. Issue fresh reminder to the Chief Judicial Magistrate, Kamrup Metro. Pertaining to closure of final report number 443/2017 dated 13/1/10/2017 of Bazar Police Station case number 394/2000. Copy of this order also be communicated to the district and session judge Kamrup Mallipur Metropolitan for his necessary information. Please come. Twenty-fifth of it. Okay? We'll have it on 25th.
Wait, much.
Report from
45 item. Mandal may not be here. We'll take it up at 2 o'clock. Yes, you have the report.
Yes. And keep cover. Before it-
Inform Mr. Mandal. We'll take it up at 2 o'clock. We'll pass the order.
Yes, ma'am.
You are appearing for Mr. Mandal.
Yes, ma'am.
Cover.
We'll pass the order at 2. Mr. Sharma, will be here at 2. We'll pass the order. Item number? 9. Let's see whether we reach or not. We'll take up item number 1. No. Item number 1 will be taken first. You are in item number 1.
No, 9.
We'll see when the 9 is reached. Don't worry.
It may be taken after.
We'll see. These are old matters, we're not just. You are appearing in those criminal matters. Okay, as on TP court. After this, we'll take up those. Mr. Sharma, can you tell us where is the victim now? No, that's what we know, but where is the victim now? With her parents?
Yes, my lord. Victim is with her parent lord.
What's your good name?
K. Islam.
For the petition. And Mr. P. Sharma, petitioner senior government. For the state respondents number 1 to 7. The petitioner herein is the father of a minor girl. The petitioner victim. It is alleged that the victim, a minor girl, daughter of the petitioner, was kidnapped by the private respondent numbers 8, 9, and 10. On 27/07/2023, around 2 p.m. from his house. The petitioner on 31/7/2023 lodged an FIR before the Nair Alga police outpost in that regard. Which was accordingly registered as Bilasipara Police Station, case number 275/2023. On 01/08/2023 under section 366 in the capital A of the IPC, corresponding to TR number 497 of the bill. As the minor victim girl could not be traced out, our father, I, the petitioner, filed his habeas corpus petition on 25/08/2020. As per the report of the police from the Superintendent of Police brief, having jurisdiction over Bilasipura Police Station, submitted a report that lookout notice of the accused respondent number A was issued immediately after registration of the police case. Who allegedly kidnapped the minor victim. And such notice was published by the media, in the media, in the District Information and Public Relations Office and other places. Thereafter, on receipt of the technical inputs about the whereabouts of the victim, regarding whereabouts of the victim, a 3-member team led by one sub-inspector left for Bangalore on 03/09/2023, and search was conducted in various hideouts along with police from Bangalore, Karnataka. Ultimately, the minor victim girl could be recovered on 05/09/2023 around 12:45 p.m. from Bahalpur, Sapur, district Dhubri. Then she was taken to Dhubri Medical College for her medical examination. And then was placed before the CWC Dhubri. As per the order of the CWC Dhubri, the minor victim girl was then kept at Care India Foundation Center, Jakarta, Bilaspur. Later on 07/09/2023, the minor victim girl was produced before subjudicial judicial magistrate. Please take your seat. Bilaspur, for recording her statement under section. And thereafter, on completion of such recording, statement of the victim under section 164. As per the direction of the inspection, the minor victim to her part in the evening on 07/09. Pursuant to our earlier order, Mr. Sharma Lani, additional senior government. List 2. The Superintendent of Police Dhubri placed a copy of the 164 chairperson statement of the minor victim in state police custody, recorded on 0709. That would be different. Right. Since the minor victim girl has already been recovered and been handed over to the petitioner, father of the said minor, nothing survives in this habeas corpus petition. According to this.
I'm obliged.
What are you concerned? What is it? PPS.
47 and 48.
May I please, Lordship? Lordship, I have
You
received.
have received the paper.
Yes.
Buddha matters. Paper. Not. When do you want this? Only 2023 matter. When do you want?
Hearing.
After 3 weeks or 4 weeks, sir.
As you say, we'll accordingly.
After 4 weeks, sir. Since it's already ready, Lord. Paperwork is also ready.
As agreed by the land council for the appellants as well as the land public prosecutor. I'm left to right. Is this matter for hearing? This appeal, this just the appeal. These appeals were admitted for hearing on 28/08/2020. Okay? That agreed by the appellants as well as. Right. Place this matter for hearing. In a serial course.
Mr.
Highly obliged.
May I please your Lordship? Lordship, as per earlier order, respondent 8 was the honorable court ordered directed the respondent number 8 to file the affidavit, and accordingly they have did. And Lordship, my request is that now all the pleadings are being completed, so matter may be fixed for hearing.
What is the number one prayer?
Hmm?
Have you gone through a number one prayer?
Yeah. And that the prayer is that your Lordship, I mean, the any due to I mean that they due to there should be an impartial inquiry as it is a matter of custodial debt.
My lord, judicial inquiry is already pending as per our evidence. And record number 8 is a D police.
Not available.
I'm appearing for record number 7, 1 to 7.
Okay.
8 is the private witness. My name is in proceeded.
D Kalika. It is D Kalika.
What is the mention about the judicial inquiry?
My lord, in our activity opposite.
File when?
Paragraph 50. That is exactly statement given by
Which affidavit? When did you file that?
we filed this affidavit on 1st of September. 2023. Made NPCL that the file out is taken up with the inquiry and number 8 is yet before the honorable court. And answer the question put forward by
Where is that? When did you file it?
paragraph 50
Of your affidavit?
of the affidavit filed by record number 3. Superintendent of the
Which paragraph?
paragraph 50.
When this inquiry started?
My lord,
What's your good name? Oh, Mr. You're appearing?
petitioner, my lord. In fact, my lord, I could not think the matter will be taken up today, my lord.
No, it's okay, doesn't matter. We are not taking away that way. We want to know the status of the judicial inquiry. There is a judicial inquiry pending. We
Yes,
should know the status.
my lord.
Will not interfere since there is a judicial inquiry. After the inquiry report is out, then we'll see whatever is possible.
Basically, we are having twofold prayer. One prayer is for
The last prayer, the first prayer cannot be considered. The last prayer will be considered only after the inquiry report, the judicial inquiry report, right? We have lots of urgency to go through it. Pertaining to the incident involved in Gosaigaon Police Station case number 23/2021 corresponding to TR case number 30/2021. Involved in this habeas corpus petition. Habeas corpus materially. Presently, a judicial inquiry is under process. Your good name?
I'm appearing for it for the first one.
Ms. E. Sharma. Government Advocate Assam.
Chapter 7, no?
Appearing for the state respondents. Submitted. That the respondent number 8 has already deposed before the state judicial and authority of the judicial inquiry, before the concerned authority of the state judicial inquiry. Placed on 38th of April, enabling the state respondents to apprise the court about the present status of the state judicial inquiry pertaining to the incident involved with this. Tell us what is the status
Highly obliged.
of the- Rashid was here. Where is he? He was here. Mr. Sharma, someone to find out whether Rashid is available.
Yes, yes. He was available, Lord.
Yes, he was. I have seen him
Yes.
dictating the order. He was here.
Sorry, my lord.
Doesn't matter. Mr. Pratik, please take your seat.
this stuff.
Mr. Sharma, what do you have to say?
My lord, in this case, notice was duly served, lordship.
Say, it was issued on 17th of May
May
2007,
7. Yes, sir.
and date was fixed on
25
25th of June
June 2000.
2007.
Yes, sir.
Then notice was
Notice was duly served and notice was returned after service, lordship.
the process server's report was of 24th of June 2007.
Yes, lordship.
The very next day was the case.
Yes, yes.
What do you have to say?
Yes, lordship. Proceeding was granted ample opportunity.
How do you say that?
Yes, lordship. Next date was fixed for 24/7/2007, lordship. For lordship
No.
necessary order, lord.
Who identified her? Kamra Nodi.
Yes, lordship. If you-
Initially, it was in a different police station. The jurisdiction belongs to Barpeta.
Lordship.
Earlier, it was Harhog.
Yes, lordship.
Whether this amounts to service of notice and the proceeding.
Lordship, process server report is that, Lordship, Mohahoy.
True, process server is there.
Yes, Lordship.
Then while disposing of the matter, the LVO, the teacher,
Yes, Lordship.
his statement has been recorded. Look at the report.
Yes.
Whether the service is complete in this manner without being identified by somebody. But none of the reports we found that always there is a Gampura while serving notice on the property, because the property needs to be identified by the concerned Gampura in the village. But there is nothing,
No witness.
nothing.
Yes,
So how will you say that? When the matter went out from Turbo police station to Korpeta, the notice backside it is there. See the date. Only the next day of the fixed date tribunal, that is why the process server immediately the previous date, giving a date, he has made a service or what? That also in absence of any other witnesses. These are the matters you see, no point keeping it. There is nothing before the tribunal to hold it that this was duly served, at least from this particular report.
Okay, look, this. No. Hmm?
order three,
Yes, Lordship. Five.
5E.
Five. Mm.
If you read,
If the proceeding or an available adult member of his or her family refuses to accept notice, the process server shall give a report to the foreigners tribunal in that regard, along with the name and address of the person of the locality who was present at the time of making such an effort to get get the notices served, provided such person is available and willing to be a witness.
so reading this, what do you feel? That there is a requirement of
Lordship,
somebody as a witness?
yes, Lordship, if proceeding himself accept this notice, then regarding the signature of other witnesses is not necessary, Lordship, as per this provision, Lordship.
Do you think that is the some impression?
No, Lordship.
Do you think that is the some impression of the petitioner? It's not even properly thumb,
Yes,
impression is not
Lordship.
properly, you can
No.
see there,
Yes,
it's not
Lordship.
proper.
Yes, Lordship.
So
Yes. RTI of Halima Bibi.
somebody made white papers, otherwise you have seen what is there. Ready? तुम्हें फोटो फोटो लगते ना लगे कटेगा Some of the cases, in most of the cases, there is in presence of witnesses.
Yes, Lordship.
But here something is different. What do you have to say? Do you think this is convincing?
Yeah,
Is it convincing?
in this case, Lordship, a person concerned process server could not able to trace out the procedure, Lordship. So, in presence of witness, Lordship, that report was made, Lordship. In this case, in presence of one witness, Lordship, of
Where
the
is
same locality, Lordship.
Where is that?
Yes, Lordship. In this case, Lordship.
In this case, there was an witness.
Yes, Lordship.
Because in the case in hand,
No, no witness, Lordship.
no, that's what we are asking you, whether, whether, are you convinced that notice was duly served?
Lordship.
Because of the thumb impression, we are not.
Yes, Lordship. Yes.
You can send it to the forensic if you want. You can send it to the forensic. Tell us, tell us. What do you have to say?
If this is the thumb impression of Hamida Begum, Lordship, actually he accepted this notice, then presence of other witness or signature of other witness is not necessary. As per order 3, Lordship 5.
See, basically, what we are asking you is this. Think this kind of thumb impression, are you convinced that it was duly served? Please give us the record.
Originally, Lordship reference was made in the year of 1998.
That is not the issue.
Yes.
Mr. Sharma, something is not fair here. First, it was issued to the proceeding in the Chorbo police station, right?
Yes, Lordship.
Because the copy of the notice is not, second copy is not before us.
Yes, Lordship.
Then, turn next page. the Turbo police station returned it.
Yes.
Because it is under the jurisdiction of the Borpeta Road police station.
Yes.
Turbo police station returned it on 6th of June
Yes.
2007.
Yes.
Then come to the front page. And again it was on 21st of June,
Yes.
right?
Yes.
There is English letter 21st of June, but in Assamese also there is 21st of June, Ekul Stoy. Then
Yes.
the Assamese 6, they have made it 5,
Yes. Yes, Lordship.
but down below they could not, they failed to do it. So it is 21st of June. Borpeta Road police station received it on 23rd of June,
Yes, Lordship.
right?
Yes.
And how the notice could have been served upon the proceeding on 21st of June?
Yes, Lordship.
That is the reason we're asking you. See, it is very clear. It was returned to the tribunal.
Yes.
Tribunal reissued it on 21st of June. Borpeta Road police station received it on 23rd of June. How can you say that it was served on 21st of? You have seen that?
Yes. Yes.
So
Yes, Lord.
you want to say anything else? This is your record.
Yes, Lord.
After it was returned by the Turbo police station, the next it was issued on
It's on 21st.
21st.
Yes.
Then Turbo police station received it on 23rd.
Yes.
See in the top. Borpeta Road, Borpeta Road. There are two seals. First seal is of the Turbo police station.
Turbo police station.
Second round seal in the first page of the notices. Second round seal is of Borpeta Road police station.
Yes, Lordship.
It is on 23rd.
Third.
Then how can the process server can say that it was issued to her on 21st of June?
Yes, Lordship. Yes, Lordship.
First of all, they are illiterate.
Yes.
Don't do it like that.
Yes, Lordship.
Yes. Now when will you appear? Give us a date.
Within
Give
10,
us a date. Give us a date. Accordingly, you will appear, file your written statement
my lord.
and evidence in affidavit.
Today's Miller 6 this. So Miller by 20th Miller.
Hmm?
By 20th March.
Two zero করতে না?
Bueno,
হ্যাঁ, 20 খোলা আছে।
no, sigan.
আজকে কি?
Yes, yes, yes.
Yes.
Done.
Vale. Twentieth March Wednesday. Miller.
We appear on 28 to 8
My lord.
because in between there are certain holidays. And Mr. Sharma has also to return the record,
Yes.
Oh, yes.
right?
Right.
You appear on 28th of
March.
March. And on that day, you will file your written statement as well as evidence in affidavit. Both. Thereafter, the tribunal will
First, no?
dispose it of in accordance with law as provided in the district. Mr. Sharma, you will get back the record
Yes.
tomorrow only.
Yes.
And you have to send it back to the,
Yes, Lordship.
this is under which police station now?
Now they are Miller Baksa.
That is the thing. It has to be transferred to
Bak-
Baksa probably.
No, no, Baksa is district now Miller. And district PS Miller
No.
is
Police station Govardhana.
Govardhana Miller. But one thing Miller, he is in custody.
Huh?
He is in custody.
Since when?
Since Miller 30th of Miller October 30/10/2023.
You'll get the order tomorrow in the second half,
Right.
not in the first half. Right?
My lord.
And
He is to come back, release on bail, my lord. Or we can do it.
we'll try to get it. We'll do it at the earliest. Let us see. If you can get the order by tomorrow. Is that Matia?
Yes, ma'am. Well, Prabhat.
You have filed any miss case?
No, it is in this main distribution, my lord.
Okay.
Discuss for another case.
We'll pass the order. When she was taken into custody?
30th of October 2023. I have mentioned in paragraph 11. I have
Just
mentioned.
note down. Yes, para 15.
11 also, my lord.
What is temporary jail? They are not kept in jail. The detention camp.
Anyway, my lord, there is.
Don't write jail. Already there's a PIL.
Oh,
And the
my,
PIL has confirmed it. It is detention camp.
yes.
Don't write
It is
jail.
my
Earlier there was a, that is the reason why it was a PIL. They said they were kept in jail. Then it was considered, verified, government of Assam filed affidavit. Then detention camp. One at Kerspur, one Matia.
but in Okolatma, my lord, they have written statement.
Huh?
In Okolatma, there is Okolatma from jail, my lord, and that Okolatma is written
It
that
is
was, that
side by
was,
the, it is a nowhere.
that was easier.
Personally, I have visited many jails. For them, there are part of the side of the jail, there are camps. They are not kept with the other.
No,
Jail convicts
Golpara
or
jail
others.
is in town, my lord, and this Matia, this about, my lord, about 10 kilometers distance, my lord. In location is, I know.
For their only purpose, state has constructed those sets. I know that is available in that PIL. Everything is there. But if it is under, why it will go back to the state tribunal? It has to go to Baksa now.
Yes, my lord.
Hmm?
Now, earlier, it was cases studied in district Borpata, my lord.
No, earlier. Now,
Now, records are there in Borpata. Again, my lord, now I
Yes,
am
Lordship,
selling
from
about.
Borpata, I have received this record.
we'll send down to Baksa
Lord,
necessarily.
yes, Lordship.
The address of the proceeding is clear. It's in Borpeta Road earlier,
Yes, Lordship.
right? Now, the same address.
Falls under Baksha. But office, my lord,
Lord.
in Borpata.
Lordship may send the record to concerned Borpata Tribunal, Lordship. Then that tribunal will do the needful as per their jurisdiction.
Then we have to extend the date, not by 28th of March. The entire record has to be sent down to the Superintendent of Police order Baksa by the Superintendent of Police order Borpeta. To clarify it, then it will be taken up by Superintendent of Police.
Yes, Lordship.
What do you have?
I get the instruction, Lordship. Second,
After some time?
after
We will
some,
not take it. We have already disposed of. Give it
yes,
to us.
Lordship.
We'll be here.
Yes, Lordship.
Okay. Whether it will can be straight away from the court, it can be sent back, or it is because it will be judicial order.
Yes, Lordship.
Jurisdiction is now under Baksa.
Yes, Lordship.
So record is before us.
Yes, Lordship.
You are required to send it to the concerned judicial tribunal.
Yes, Lordship.
In the judicial order, we can visit to directly to the, or it is a matter, the Superintendent of Police border, Borpeta have to send it to Superintendent of Police border Baksa, who in turn have to place it before the Foreigners Tribunal Baksa.
Yes, Lordship.
So which way? In a judicial order or ask your authority?
Yes, yes, Lordship.
Anyway, we'll get the order tomorrow.
My lord.
Let us know.
Yes, Lordship.
Talukdar, Hazarikati, Talukdar, Hazarikati.
It will be listed, probably it will be
In the
listed.
order, you'll see. Let Mr. Sharma tell us.
Mal.
If not today, by tomorrow, will be dictated in the order.
I shall inform your lordship today itself, lordship. Yes, sir.
So the,
Yes, we need your information.
he has been terminated, my lord. The respondent has been terminated, my lord.
That's why you ask you whether it is still in paper or.
No. Practically, he has been terminated. I think it was issued on the 4th or the 5th. The IS is in some, he had to go and meet some dignitaries and all. He could not send me that order, but it was signed on the 4th. It is, sir.
Photo mark.
When I asked him on the same tone, my lord, he said the daughter of that person was undergoing matriculation examination. He said, I did not have the heart to him while the matriculations were going on. So I've signed it and I have handed it over to him. What has come unofficial to me? The other part of the order, my lord,
Okay, we'll pass the order, final order, right?
my lord.
Third, Mr. Armazul. Learned Standing Council. Department of School Education. On specific instruction. Mr. Mazumdar submit that the order dated 26/06/2023 no, the order dated 19/02/2024 of the Secretary Government of Assam terminating the service of Subodh Kolita, earlier Lower Division Assistant in Pamundi High School in 1999. Terminating election. Copy of you. The order that is terminating service earlier Lower Division Assistant Pamundi High School has been served when they said incumbent by the concerned inspector of school.
Well, the inspector of school was the appointing authority, so he has terminated the service subsequent to this order.
By which order?
Well, the order that 4 losses will be changed. I'll get the copy. I'll produce the copy.
Give it to him.
Yes, yes.
Can I write it? Mr. Mazumdar submitted before that. Pursuant to the order dated 19/02/20 of the Secretary Government of Assam in the Department of School Education. The Inspector of Schools, Kamrup, any number to lift order number, capital E, that's capital E, that's 48841, 3102. The Secretary Government of
The order to immediately be reported to the
the Inspector of Schools, Kamrup, by its order dated 04/03/2024, terminated the service of Sri Subodh Kolita, was appointed as an LD, Lower Division Assistant in Bhundi High School, 1999. later upgraded as assistant teacher. And the copy of the said order, there is 040324 of the effect of it has also been duly served. Nothing said. So good. Is there?
I have just got the information, the Subur Kolika is refusing to receive it,
Doesn't matter.
but it has been issued. He is refusing to receive it.
Or you can do one thing.
That copy of the order I'll give up. I'll
No,
give
no.
up.
This part, the IS can give a copy along with this statement. Just
Yes,
2-page affidavit
yes,
by Monday.
yes,
We take it up on Tuesday.
yes. That will be.
That will be.
Yeah, thank you.
You better file a caveat. Better file a caveat because even if the petition is filed at this stage, everything will be high hearing. That's the reason because the background of the case will not be known to many.
I will inform the other councils that this name comes up, I should be. If this name comes up in a writ petition, I should be informed is what I'll request my colleagues also. With all the records I'll be there.
What is this?
Item. Yeah, my lord,
That matter?
the complaint where the government had
council-
interfered.
council.
Yes. Even today they are not.
Nobody is appearing over.
The cause list shows their name, my lord, the display board shows that the matters will be taken up at 3.
Why council is not appearing?
Actually, my lord, practically what has happened is council wants the selection to go on. Petitioners want it to happen. Government is the only entity which is trying to stop it because of the complaints which lordship will find at page 60. Answer scripts were being rotated to the invigilators to have them signed. And that is stated by the invigilators.
You are going to file that affidavit by Monday?
Yes, yes.
We'll have the other matter on Tuesday. We'll also have this matter on Tuesday.
Tuesday. I'll inform the SA council also, my lord.
Not required. Their names are figured in the
Yes.
list, right? What is the requirement?
Yes.
Don't do it. But Mr. Armugin, the council appearing for the no representation on behalf of the respondent number 1 as well as the respondent number 2 and 3. Chairman and Secretary Assam has seconded. Has it been merged? The council has been merged or
To some extent, administratively they are different, the courses are different, but they just want to have one head now.
list on Tuesday?
Cases are filed separately.
It will come on Tuesday.
I'll
May I please, your lordship? Lordship, I am praying for some accommodation, lordship, to submit the records.
Tell us when you'll do it.
19th, lordship, 19th of March. Other review petition is fixed on that day.
Give us a date, we'll allow you.
19th, lordship, 19th March.
On the prayer of the council for the Department of School Education. Ms. Gogoi, right?
Ms. Kumar, S. Kumar,
As for. Full name?
Satyavati Kumar.
Matter be listed again on 19th of March, enabling her to place the relevant records.
Lord.
Intermediate.
Lord, may I please, Lordship, in the earlier case, Lordship, petitioner has to appear before the FT2nd Borpeta Lordship after getting bail from S. Border Bakta. Lordship,
DP matter koi bole.
earlier Lordship case, Lordship.
DP bench.
Arrested by whom?
Lordship,
Arrested by whom? taken into custody by SP Baksa, SP Border Baksa or Borpeta? It is not there in the petition. Just say it taken into custody on 31st of October.
Yes, Lordship. I will inform Lordship.
To get
Otherwise-
information, who took her in custody,
Yes.
whether the SP Border Baksa
Yes.
or SP Border Borpeta,
Borpeta.
right?
Lordship.
If it is SP Border Baksa, Border Borpeta, then bail has to be granted to her by SP Board.
Yes, Lordship.
Find out
Yes.
and we'll pass the order.
Yes.
We are here in the chamber, will not go
Yes.
till 8 o'clock.
Yes.
So you do the needful and get the information.
Yes.